Good morning, everyone. Thank you for joining us. Happy International Women's Day. My name is Brian Wasselou, and I'm here today with my colleague Connie Chung, who should be joining shortly. We have more than 2,500 registrants for today's webinar. So that's my mom and a few hundred of her friends, but a lot of other people who are no doubt here because the topic is a significant one. We're talking about termination of employment. There have been developments that present risks to employers. We want to help you try to avoid or defend against some of those risks. And the way to do that is to stay on top of what's happening. So the format will be like our other HR review presentations. Connie and I will present until roughly about 10 o'clock, and then we'll answer questions until about 10:30. If you have questions for us, please type them in the Q&A box. That's on your screen, not in the chat box. The chat box should be disabled anyways. So we'll do our best to answer as many of those questions as we can. If we can't get to your question, then please reach out to us after and we'd be happy to help. Finally, a recording of this presentation, along with the slide deck itself, will be available on our website in the next day or so. So with that, let's get started. So today we have for you a discussion about employment contract considerations. That's where we're going to start. Case law has continued to examine and attack the enforceability of termination clauses. So what does that mean? I will also discuss how other provisions, ancillary provisions in the contract that aren't on their face, the termination provision, can impact your termination provision. Then the termination goes ahead, the person is lost their job, and we know about the duty to mitigate, their obligation to find a new job. There's been some updates in the case law as to what that means. What does an employer have to do and show to demonstrate the employee has failed to meet their responsibility to mitigate? And specifically, there's one case in particular I wanted to draw your attention to regarding a fixed term contract, and it really illustrates why a proper termination provision can be vitally important. So I will then pass it off to my colleague Connie, and she's going to discuss bad faith claims, which we're seeing more of, or which is to say we're seeing more of them succeed now. So she will talk about what you should do and what you shouldn't do when you're drafting a termination letter and conducting a termination, considering how to minimize the risk of reputational damage to an employee, and when would a delay of payment of statutory entitlements increase potential liability. And where that's really going is we are seeing now situations where if employers slip, they can attract what's called bad faith damages, even if I might say, and I truly believe, they haven't acted with bad intent. Connie will then finish talking about another issue related to post-termination income, specifically that of CERB, the Canada Emergency Relief Benefit that was provided during COVID. And what does that mean to the damage award? So, employment contracts. In order to discuss the changes to the law and why they're important, I am going to spend a little bit of time here either refreshing or informing you, depending on how familiar you are with the concept of the damages an employee is entitled to when they're terminated and how the contract can impact that. So there's buckets of entitlements that employees have. It goes back hundreds of years back to when the common law judges in Britain and then Canada would call employment law the law of master and servant. We obviously don't call it that anymore. But that's where this concept came at common law, that if you let someone go from their employment, you have to give them advance notice that you're letting them go. Or if you don't actually give them the advance notice, you have to compensate them for what they would have earned in that notice period, right? And that's where if you've talked about this concept, you've heard of the rule of thumb of a month per year of service, which there might be reasons to question as of late in some of the cases that are coming out, and not in a good way, unfortunately. But you have that entitlement. That's a month per year of service, a significant entitlement. You can change that. Two parties can enter a contract and they can say, here is what will happen when employment ends. And so, of course, a lot of employers did that with their employees when the employees get hired. So they have some predictability as to what the entitlements are at termination, and they can limit the entitlements because they don't want to pay the large common law liability. Okay, so that the concept of providing that certainty and clarity. But there is a third piece, and that's the statute. So that's where we talk about in Ontario, the Employment Standards Act. It goes by different names in other provinces. And the Employment Standards Act says, here's what an employee must get. And that's where we see the 1 week per year of service for notice, up to 8 weeks. And then potentially, if you have a large enough payroll and the employee's been with you for a while, a severance payment, that's another week per year of service, up to 26 weeks. So basic entitlements there, but much less than the common law large amount. So what's happened is when employers are trying to use that contract to say, you will receive the employment standards amount, you will not receive the full common law amount, or sometimes the contracts pick a number that's north of the Employment Standards Act, but not quite a full common law entitlement, but they still want the predictability. You can still do that, and we advise that it's good practice, but, and there's always a but, isn't there? The language you use to say you will only get the Employment Standards Act or you will only get X can never give less than the Employment Standards Act. If it does, that it's in a violation of the statute, and it can't do that, so it means that your termination provision will not be reliable. You can't use it at all. And then the employee is back into that big bubble of common law liability. Okay, so employee counsel have helped plaintiffs try to attack a contract that limits that entitlement so that their client can get the common law amount, which is much larger. And they do that by trying to find anything in that contract that violates the ESA, that violates those minimum standards. Okay, and then that contract provision goes and they have their common law amount of damages. Okay? And so that's what a lot of the cases have focused on. Does the without cause provision that says in the event of your termination, you'll receive the minimum requirements, the Employment Standards Act benefits will continue for the period required, and all the attacks are there. Well, you didn't mention the right kind of benefits, or you didn't properly refer to severance, and any mistake could get that provision thrown out. So what is the big change that we want to talk about? The big change that we wanted to talk about is the courts expanding their focus to other termination provisions in the contract. What specifically do I mean? Well, this is the case of Waxdale. It's been around for a couple of years now, and I will get to the cases that have followed it and show you what has happened and what it means. But this was a big one where this got a lot of attention. So in Waxdale, the employee was terminated without cause. There was a without cause provision in the contract that limited them to the employment standard minimum, and it was good language. There was also a just cause provision, as a lot of contracts at the time might have had, that said if you're terminated for just cause, you don't get any notice, because that's what the common law would say. If you're terminated for just cause, we don't have to pay you. We don't have to compensate you for notice. And in this particular case, it also went forward to enumerate several different grounds that would be just cause. So if you do any of these things in the long list, that's just cause, you get no notice. So what specifically was the attack here? Both the parties agreed that the just cause provision had a problem, because that just cause provision listing all of those things and saying you get no notice did not comply with the ESA. And that's because it's now clear that the Employment Standards Act has a different approach to notice entitlements, severance entitlements in the event of misconduct. The Employment Standards Act doesn't refer to just cause anywhere. It talks about willful misconduct, willful disobedience. That's not condoned, it's not trivial. So the courts have clearly, and I'll revisit this in a few slides, but the courts have clearly said that is a different and higher standard. So if you have a contract that says we can terminate your employment for just cause and owe you nothing, you have now stepped offside the ESA, because there could be circumstances. It doesn't matter if in this case their circumstances arose. There could be circumstances in which this contract violates the Employment Standards Act, and that's enough to remove it. So even though this was a without cause termination and that provision was fine, the court decided that you had to read all of the termination provisions together. It meant that even though they might be separate paragraphs and you have without cause here and for cause down here, they all relate to termination. And the Court of Appeal decided, no, we're going to look at the termination provisions as a whole. And if one of them has a problem, they all have a problem. And that means your without cause limitation provision is gone because your with cause provision violates the Employment Standards Act. And it matters not to us that this was a without cause termination. So the employee was awarded notice. So where did it go from there? Last year, we've seen more cases come through trial, and then another case from the Court of Appeal, the Canon Design case. So this was another situation where the employee was terminated without cause. It was another situation where they made the Waxdale argument that the just cause provision suggesting that no notice would be available was offside the ESA and not enforceable. So relying on Waxdale, the employee made that argument and was successful. It's interesting because I've sort of buried the lead. At trial, when the case first came up, the trial judge looked at this and wasn't really impressed with the overly technical approach that Waxdale was offering. The trial judge looked at things like the sophistication of the parties. The plaintiff here was a sophisticated and intelligent woman of experience, I believe was the language that the trial judge used, and was represented by legal counsel. So the trial judge basically said, nobody here was trying to violate the ESA. So we shouldn't be picking at these things and trying to find violations where it was never the intention. And then he went on and also questioned and attacked the issue of whether we should have this distinction between just cause at common law and willful misconduct under the ESA. I'm not going to spend a lot of time on that. The trial judge lost on that issue, and it's been sort of roundly and repeatedly reinforced by the courts since then. But what about this other concept that the parties knew what they were doing and had legal counsel? And shouldn't we let them contract freely in that sense? The Court of Appeal said no. It's the language in the contract and whether it violates the statute that matters. It's not the subjective intentions, as they put it, of the parties and the fact that they had legal counsel. So the court isn't going to adjust their approach. If the language violates the ESA, it is gone. Doesn't matter. They're not going to pull in the intentions of the parties to try to fix it. And so in that case, again, we have a situation where the just cause provision didn't account for willful misconduct under the ESA. It went by the wayside. Therefore, the without cause provision went out by the wayside, and the employee received their notice. There's another step that the courts have taken, and this is the Henderson case. Okay, so this was another circumstance where an employee was terminated without cause, and they had a without cause provision that covered the bases, looked fine and adequate. However, there were two other provisions in the contract. In particular, the conflict of interest provision and the confidentiality provision. And in those provisions, and we're talking, again, just so you know, it shouldn't really matter, but paragraphs that are wholly separate in the contract, but they refer to the fact that if you commit a conflict of interest, we consider that cause and you get nothing. If you breach your confidential obligations, we consider that cause and you get nothing. Okay. So because those provisions also related to circumstances where the employee would, quote unquote, get nothing, I'm sure the contract didn't say get nothing, but you would have no entitlement. They are also offside the Employment Standards Act. And again, these circumstances didn't happen. This employee wasn't being terminated under those provisions, but nevertheless, that scenario could happen. It's a violation of the ESA. And so by virtue of those ancillary paragraphs, and the way they talk about termination, all the termination provisions in the contract go. And this employee was therefore entitled to their common law notice. I would also point out that in each of these cases, there was a severability clause that was ignored. So the severability clause is the one that says, court, if you determine that any clause in here is rotten, cut it out and leave the rest. But the courts are not doing that. with the termination provision, because they're saying all the little bits that relate to termination are the termination provision. So again, the point I've made is that there could be a breach, there could be circumstances that don't amount to willful misconduct under the ESA, and therefore the provision has to go. This is a bit of a pivot. This case is also helpful and instructive, but for a slightly different reason. So this was, again, a termination case. But the interesting part of this case is that there was a provision in the contract that was provided for a termination amount that was greater than the ESA. It was 12 months. And so it was, it was good. It was generous, very fair, whatever you would like to call it, a reasonable approach and provision that you wouldn't think a judge would want to come down very hard on the employer for. But the employee was pushing for everything that they felt they were entitled to. And in this case, they were arguing over a bonus because the employer did not include the bonus in the termination payments. They paid them, I'll say small less salary, what we normally call salary, their wages, although that's also a loaded term for another time. They gave car allowance and things like that, but they didn't award the bonus because the employee wasn't going to be there when they pay these bonuses. So the court looked at that and actually said, no, we think you need to include bonus in salary. And they looked at it and said, salary is not defined, so you're not telling us what salary means. So we feel that because it's an integral component, substantial and integral part of their compensation, that would have been included when you talk about 12 months salary. I think a bit of a stretch. I think most common people would think that. Nevertheless, here it is, and that's the Nader case for you. And it went through the Court of Appeal. So these are not insignificant decisions that we would expect to change anytime soon. And what it really means is it's a reinforcement that the courts are going to look with extreme detail, as much detail as possible, at all of the little components in a contract to try to find something that might be a mistake or an ambiguity. And if it's an ambiguity, it's going to most likely go in the favor of the employee. And helping with this, of course, is the substantial plaintiffs bar that is recruiting people who've been dismissed and advancing the cases for them. So what are the takeaways with these changes to employment contracts? It remains important to have a termination provision. If you don't have one, you're going to be dealing with a common law entitlement, and it's going to be a lot more than perhaps you might otherwise agree to or tie to the employment standards amount. Okay? But the reality is, if any of the language in the contract could violate the ESA, then all of the termination language is going to fall. Okay, so that's why the drafting precision is key. And as I mentioned before, if there is something missing or something that's not done as exactingly as it should be, the court will go in the favor of the employee. So you should be reviewing your contracts regularly. So as I said, these are changes that have really hit home in the past few years. It continues to change. And the best way to try to protect yourself is to review your contracts to see how they're holding up in terms of currency for any potential changes in the case law. We'd be happy to help you with that. So an employee is let go. You've probably heard about a concept called mitigation. So they've lost their job. They're now out in the world. There's actually a concept, again, at the common law, which is a term I've used before, that would say, and it actually goes, it's not just an employment law piece. When one party hurts another party, that other party that is hurt cannot just sit there and continue to bleed. If they have an opportunity to stop their bleeding, they're required to do that. This is where the concept of mitigation comes to. Now, how it applies to wrongful dismissals and notice of termination, of course, gets a little more nuanced. That's what I want to talk about because there's been some developments there. The first case that I want to talk about is a truly cautionary tale that moves us. This relates to the concept of a termination provision and also to the concept of mitigation. And that's the Terrace case from last year. So in this case, it was an employment contract that was for a fixed term of 3 years. Okay? It's important when you have those fixed term agreements that you have an early termination provision. We can end this before the 3-year period if we want to. And you'd say you get the ESA amount for perhaps, or you pick another amount, or we can end it and not provide you anything because you've acted badly, the just cause provision, right? That's what happened here, although it was without cause. So they were terminated without cause 1 year into the 3-year contract. This fixed term contract had the Waxdale problem. So their provision, they had a cause provision, it violated the ESA. So all the early termination provisions, the provision that allowed them to end this contract early with no further obligation or some smaller obligation was also set aside. Okay, so the employee is pursuing the remainder of that term, 2 years left on that 3-year contract. And the courts have approached fixed term contracts that way. If you have a fixed term contract and you don't have an enforceable early termination provision, then you have to pay the employee to the end of that contract. And in this case, 2 years. And what's particularly noteworthy, frustrating, whichever phrase you would like to use, is that not just this case, but several cases, and I would just say, frankly, I disagree with it. There would be many lawyers who might disagree with it. People disagree, and sometimes people lose. The courts have decided that in that 3-year, in this case, a 3-year contract, that's like a promise. And you owe them for the whole contract. They don't have an obligation to mitigate. They have no obligation to stop their bleeding. In this case, the balance of those 2 years. Very hard to take, but reinforces the extreme importance, particularly when you have a fixed term contract, of dealing with an early termination provision. And you can actually even write in terms regarding obligations to mitigate, perhaps. So what else about the concept of mitigation? Not in a fixed term situation. We have the Summers case. So this employee was about 3 years of service, 61 years old, making about $75,000 a year. They were terminated without cause. The employer in this case did not offer them any reemployment assistance. You're not obligated to, right? I'll talk about this at the end. I mean, there's an opportunity perhaps to help an employee find replacement work, and that could serve two purposes. They might actually get work and stop some of your damages, or down the line, you might be trying to make an argument that they did not meet their duty to reasonably try to mitigate their losses. Okay. In this case, the employee remained unemployed 8 months after termination. And I'm just going to pause quickly here because it's an important concept to just reinforce. When the court is trying to fix a notice period, they do not have reference to how long it actually took the employee to find a job. The notice period is fixed at the time of termination. Okay. In this case, the 3-year service employee, 61 years old, was entitled to 6 months of notice, right? So again, there'll be other examples, but we can't hang too tightly to that month per year of service concept. He was entitled to a 6-month notice period, but you'll see that's still less than when this got to a decision, he'd been unemployed 8 months later, and the notice period was still 6 months. The fact he's still unemployed at 8 months is relevant to the concept of mitigation, right? Because it's relevant to, were there opportunities out there for him to have and find new employment? Okay, so he had sent resumes to 30 employers. He'd used Indeed, he'd networked, he'd attended interviews, but he had not received any offers. The employer was saying he didn't do enough, he didn't mitigate properly. Here's all these job postings that he ought to have pursued or pursued more vigorously. And the court was not convinced because it noted that the employer has the burden. Employee has to mitigate or reasonably attempt to mitigate. But when it comes to deciding whether they have, it is the employer that has to prove the employee has not done that. Okay? And it's also important that in this case, I mean, it was the law, but this case reinforces that the standard for that mitigation is not perfection. Okay, so the employer did not meet their burden here just by pointing to other job postings. There's always going to be circumstances where someone could have done more, is essentially the approach the court is taking here. And it's not right for an employer to point to it and require perfection of the employee in their pursuit of replacement work. The other part, there's the point I just made about perfection. The other part, and there are comments about whether you need expert evidence to substantiate that these postings were something that should have been pursued and would have likely resulted in employment. I'll have more to say on that with some other cases, but really in this case, the employer didn't have evidence of any of that sort, whether it was from an expert or even from one of their own management employees. They didn't lead that evidence. And so they had not met their persuasive burden to convince the judge that the employee had not mitigated properly. And therefore the damage award, the 6 months notice, was not reduced. The last mitigation case that I want to focus on a little bit puts some more meat on the bone. So in the Lake La Presse case, a general manager, she had been working there for about 5.5 years when I wanted to say plant, but the office was shut down. Okay, so she was let go. Everyone else was let go. She still did not have a job 2 years after. Okay, she was afforded, like they did offer her outplacement services. And in fact, the employer was arguing that she didn't properly mitigate because she actually didn't take those outplacement services for 2 months. And then when she did get going, she was too slow and she could have done a lot more. And so she was really dragging her heels for about 4 months post-employment. And they also focused, and this becomes an item the court focuses on, she was applying for jobs that were vice president jobs. Okay? Her title in the previous job was general manager. So the trial judge agreed with those points, and also particularly focused on the slow start. And so discounted the notice period by 2 months. So this was a 5.5-year employee. She was about 50 years old, and she was awarded an 8-month notice period. Okay. At trial, the judge felt mitigation was not met fully and discounted it by 2 months down to 6 months. And the employee appealed that. And the Court of Appeal disagreed with the trial judge and reversed the finding on a failure to mitigate, restoring the award of 8 months notice. Okay. Now, how? The idea is that the employee is allowed to hold out for comparable employment. They don't have to underemploy themselves just to stop that bleeding, as I said, okay? And the Court of Appeal particularly focused on the fact that there was too much emphasis placed on this idea of, well, she was a general manager and she's applying for vice president positions. And the court looked at it and said, okay, but you're just focusing on the title, and she's led evidence in this case about what her duties were. And her duties and responsibilities were very analogous to the types of vice president jobs she was applying for. She had no obligation to lower herself to, quote unquote, lower herself to take a general manager role by title and label, as opposed to a job that was similar to what she was doing with similar compensation, because it happened to have a vice president. These jobs happen to have the vice president type title. So the Court of Appeal turned that over. And before moving on to summarize that, I wanted to just point out that from this case, the concept of approaching that mitigation piece is a two-step analysis, okay? Firstly, you're looking as to whether the employee has taken reasonable steps to mitigate. And we've talked a lot about that in these cases. The other thing I hinted at, remember when I mentioned experts or what have you, the other piece the employer needs to establish is that had the employee taken reasonable steps, it would have resulted in employment. Okay? So the Court of Appeal here actually said, the trial judge is not wrong. She dragged her heels. And, those first couple months, she really didn't take the reasonable steps. But on the second piece, the employer hasn't convinced us that if she had taken those steps, she would have found a job, because that then throws back into this idea that she'd been looking for so long, trying to find a vice president position. Maybe the potential future employers are also hung up on the title. For whatever reason, I shouldn't say that. What I mean when I say for whatever reasons, I'm guessing as to why the potential employers might have said no, and she wasn't finding an actual another job. She didn't. The court looked at it and decided that there was really no evidence that she would have found something had she only started earlier. In fact, the suggestion was the opposite by the fact she was still unemployed after 2 years. And the court did actually say in some helpful commentary, like, they are not to be taken as saying you need to have an expert, okay, to lead that evidence. The employer does have to lead some evidence, but the employer could actually also convince the court by inference, okay? So in this case, it was wrong to, or the court was not willing to make an inference that jobs were available and she would have gotten a job if she had only started earlier. But there might be cases like that. So they use an example, if an employee had been let go and they waited a couple of months to start looking, but once they started looking, they actually found a job in a month and a half, then it might be very reasonable to make an inference that if they had only started right when they got terminated, they might have found a job a month and a half in or 2 months in, right? So there's still potential room to push on this mitigation issue, right? It's going to depend on the particular facts of the case. But the burden to demonstrate that failure to mitigate is high, and it's on the employer. If you want to set yourself up for that type of an argument with respect to whether the employee did what they were required to do, you have to prove it. You can help yourself by providing outplacement counseling if you wish. Again, it's not a requirement, but this is where that could help you both from a legal argument perspective and maybe helping the employee actually get a job. You could provide a positive reference letter if you're comfortable or if it's possible to do that. Take pieces from positive performance reviews as at least so you can at least say something positive in the letter. Mindful that if a judge sees a legitimate reference letter, it will be more persuasive that you tried to help. You can research comparable positions, focusing on the nature of the job, not just the title. Don't get hung up on the title. And you can send that to the employee or counsel. If counsel are involved, counsel can send it to counsel. And keep those records, right? Because at the later point in the litigation, you'll be asking, why didn't you apply here? What was it about that job that you say is not appropriate? And then if this becomes an issue at the trial, we can have someone from our company say, no, that job is, we look at the duties, is very suitable, yada, yada, yada. But we're putting the evidence forward, okay? Lastly, again, bit of a sidestep to the other issue. Don't forget that if you're entering into a fixed term contract, you want to ensure you have a termination, early termination provision, and that it has proper enforceable language. Okay? And again, we'd be very happy to help with any of that. So with that being said, I am going to turn things over to my colleague, Connie, and she will take you through the issues of bad faith conduct in terminations.
Thank you, Brian. Good morning, everyone. I'm going to spend some time today talking about damages for bad faith conduct and specifically cover some recent cases where the court has found an employer breached its duty of good faith and fair dealing with respect to the termination of an employee. Increasingly, we are starting to see employee claims include allegations of bad faith conduct. Bad faith claims can be related to the events leading up to the termination itself, and the way the termination meeting is conducted. In their claim, employees will seek financial compensation in the form of aggravated or punitive damages beyond damages for reasonable notice. And as you'll see in the next couple of cases, we have seen an increase in bad faith damages awards in wrongful dismissal claims. And you'll also see that in some of these cases, the employer conduct is not particularly egregious, but courts have taken into account the power imbalance between the employer and the employee and the particularly vulnerable situation employees are in during a termination. In a recent case involving China Southern Airlines, the employee was 68 years old and had worked at CSA for approximately 8 years. He started in a marketing and business development manager role, and near the end of his employment, he was demoted to a frontline airport services worker. The CSA ultimately terminated his employment for cause, alleging incompetence and time theft. And in addition to the wrongful dismissal claim, the employee also claimed damages for bad faith conduct of the employer in the manner of termination and the employer's behavior throughout the course of litigation. Specifically, the employee alleged that the CSA engaged in a pattern of abusive conduct, including unfair discipline, manufactured cause, and public embarrassment. And the court in this case ultimately found in favor of the employee and awarded $150,000 in aggravated and punitive damages. The court confirmed that there's two conditions that must be established for an employee to recover aggravated damages. The first is that the employer has breached its duty of good faith and fair dealing in the manner of dismissal. And the second being that the employee has suffered compensable damages as a result of the breach. And in order to establish the second part of the test, the employee has to prove something beyond the normal distress and hurt feelings that invariably comes with the loss of employment. And in this case, the employee and his wife testified that he had suffered mental distress and depression during the time leading up to and following the termination. The court held that the employer took advantage of the employee's vulnerable position as a 68-year-old with limited work opportunities. And to that end, the employee had accepted demotions and unfair discipline in an effort to retain his job with the CSA. And ultimately, the court awarded $50,000 in aggravated damages. The court found the employer's bad faith conduct included unfair and humiliating discipline. The evidence showed there were public reprimands. On one occasion, there was a computer mouse that was thrown at the employee. And he was also required to attend meetings where his faults were listed out. And prior to his termination, the employee was demoted to an entry-level frontline services position, which came with a substantial reduction in pay, which the court concluded was an effort to induce the employee to resign. There was also damage to the employee's reputation when the employer decided to make serious public allegations against him. And finally, the employer also refused to provide a record of employment despite numerous requests, which led to a delayed access to employment insurance by about 2.5 months. Now, in this case, given the particularly egregious behavior of the employer, the court also awarded $100,000 in punitive damages. Now, awards of aggravated damages are meant to be compensatory to the employee, whereas punitive damages serve a different purpose. Punitive damages are awarded in exceptional cases where the wrongful act is so malicious and outrageous that the court has decided it deserves a punishment on its own. And in this case, the court found that the employer's conduct post-termination and during the wrongful dismissal litigation warranted punitive damages. So the court found various conduct by the employer to justify punitive damages. Specifically, the CSA made serious false allegations against the employee in a public forum, which made it difficult for him to obtain new employment. The employer also engaged in hardball tactics during litigation, which was designed to cause substantial delay for recovery for the employee. And as a result, the employee was required to bring numerous pretrial motions and applications to enforce the employer to comply with its obligations to produce relevant documents and to schedule examinations for discovery. And furthermore, when the remedies and costs were awarded to the employee for the pretrial motions, the employer then still continued to refuse to comply with the court order and also refused to pay the costs award. I'm now going to move on to two other cases that were relatively surprising for employers. And you'll see that in these cases, generally they involved administrative mistakes and a lack of clarity in the termination documents, which 5 years ago, we probably wouldn't have thought would attract bad faith damages, but we now see courts awarding some form of damages for this type of behavior. And in light of this recent case law, it is our recommendation that you go back and review and reevaluate what your existing termination practices are, even though they may not be intended to be malicious or harmful, as you'll see from these cases, it still may cause you to find yourself in hot water. So this next case involved a long service employee of the Hudson's Bay Company, whose position was eliminated and terminated without cause in September of 2020 during the COVID-19 pandemic after 28 years of employment. And the employee claimed aggravated and punitive damages in addition to reasonable notice. Now, in reviewing the manner of termination and the employer's post-termination conduct, the court awarded $45,000 in aggravated damages and $10,000 in punitive damages. One of the employer's behaviors that the court really latched onto was the decision to walk the employee out immediately after the termination meeting. This was held to be humiliating and embarrassing to the employee. And given that the termination was without cause and due to a restructuring, the court felt that this was not warranted. Further, at the time of termination, the employee was also offered an alternate role in a lower position with a lower wage rate and no guarantee of hours. And the court found that this offer would have effectively extinguished the employee's existing rights, including his common law notice of termination entitlement after a 28-year career. The court also relied on the employer's decision to pay the employee his employment standards severance payment in installments, despite the employee's request for a lump sum payment for 2 months post-termination. And ultimately, the court awarded $45,000 in moral damages. Similar to the previous case, there was also a delay in issuing the employee's ROE. And when the ROE was ultimately issued, it had incorrectly stated the reason for termination. And this was found to have increased the employee's sense of humiliation with respect to the termination. The court concluded that the employer's failure to pay out wages in accordance with the ESA and its failure to issue a correct ROE in a timely manner also justified a $10,000 award in punitive damages. Now, in Russell versus the Brick, the employee was 57 years old and had worked at the Brick for over 36 years before his employment was terminated without cause, also as part of an economic downturn caused by the COVID-19 pandemic. And the employee in this case claimed moral and aggravated damages with respect to the employer's conduct at termination, and the court ultimately awarded $25,000 in aggravated damages. So the conduct in this case, which gave rise to bad faith damages, primarily stemmed from the termination letter, which was provided to the employee. Specifically, the termination letter did not advise the employee that he would be paid out his ESA minimum entitlements if he did not accept the gratuitous offer. And by failing to include this, the court found that the employer was not being honest and forthright with the employee. The termination letter also failed to advise of the continuation of benefits, which also created unnecessary distress for the employee, who was heavily reliant on benefits along with his spouse. And further, the employer also inadvertently delayed paying the correct amount of statutory termination and severance pay to the employee's RRSP, notwithstanding that both the employee and his counsel had requested this. Now, in this next case, the employee was employed as a financial services associate for a total of less than 2 years. She was advised of her termination in May of 2020, and after the termination meeting was escorted out of the branch in front of other employees and members of the public because it had been during working hours. And the employee in this case claimed reasonable notice damages as well as aggravated and punitive damages for bad faith conduct during the termination. And the court found that the employer's conduct at termination and the termination letter, which was presented to the employee, justified punitive damages. And the employee was ultimately awarded the equivalent of 2.5 months' salary in punitive damages. Now, in this case, the conduct that gave rise to the punitive damages award stemmed from errors with the termination letter that was presented to the employee. The termination letter not only limited the employee's entitlements, but also effectively increased her obligations. So specifically, the termination letter offered the employee only 2 weeks of notice or pay in lieu, which was less than both her contractual and common law entitlement. And the termination letter also required the employee to sign a release and agree to a 12-month non-solicitation clause as a condition of payment. And both these terms were ultimately found to be inadvertent mistakes made by the employer, and they were subsequently corrected by the employer once it was raised by employee counsel. And while the court acknowledged that the employer at that time was undertaking a large number of terminations in a short time period, there still remains an obligation on the employer to act in good faith. And the court found that this quote unquote cookie cutter termination letter that was drafted without appreciation or recognition for the individual's circumstances of the employee fell short of that standard required. The employer's lack of attention to detail in the termination letter, especially where the errors fell clearly in their favor, was unacceptable and therefore justified an award of punitive damages to deter other employers from making similar mistakes in the future. Now, in terms of key takeaways from the cases we reviewed today, firstly, we want to avoid trumping up a case for cause. So, this was what happened in the Southern Airlines case, right? And as some of you may know, there's already a relatively high threshold that employers are required to meet in order to successfully assert cause. And the court does not look kindly upon employers who manufacture incidents or discipline in an attempt to assert cause. Secondly, we want to treat employees with respect post-termination. Understandably, a termination can be humiliating and upsetting for an individual, and we would encourage our clients to reconsider their termination practices, to evaluate whether it may unnecessarily demean or further embarrass an employee who is arguably already in an upsetting situation. And this means reviewing things such as the timing of the termination meetings, where they're held, and how individuals are to gather their items and leave the premises after the meeting. And this is also particularly important where the termination is without cause or any misconduct. We also want to be mindful of comments made about the employee and the reason for termination to others, including the public. Not only could this warrant bad faith damages, but it also may impact an employee's ability to mitigate damages, which is what Brian was covering earlier on in stopping the bleeding and finding new employment. Now, during the pandemic, particularly, many employers underwent large-scale restructurings, which naturally increases the likelihood of making a mistake and inadvertent errors. And as you'll see from the case law, while an error may not be intended to be deliberately dishonest or misleading, and may even be corrected after the mistake is discovered, this doesn't necessarily absolve the employer of any liability. Which is why we would recommend being diligent in reviewing and ensuring that the termination letters that are being issued provide accurate information about payments and benefits to be in compliance with the Employment Standards Act, and that post-termination conduct, such as issuing an ROE or making termination and severance payments, are properly completed and also completed in a timely manner. The last takeaway is with respect to litigation tactics. And as you saw from the very first case we talked about, hardball litigation tactics are not appreciated by the court. Unnecessarily prolonging the process or refusing to comply with reasonable requests will not only result in additional legal costs for the employer, but also an award of punitive damages. I want to move over now to the topic of post-termination income and how that impacts an employee's entitlement to wrongful dismissal damages. So Post-termination income is generally deducted from any wrongful dismissal damages award. And since COVID-19, various lower level courts have considered the issue of whether the Canada Emergency Response Benefit, also known as CERB, the CERB payments that were received should be treated as mitigation income. Now, throughout 2021, 2022, the decisions had gone both ways with some uncertainty for employers, but we will see now how a decision from the BC Court of Appeal has ultimately changed that perspective. So in Yates, the employee was laid off at the onset of the pandemic, and after she was not recalled back to work following the layoff, her employment was deemed terminated as of the start of the layoff period. And during the layoff period, she had received $10,000 in CERB payments. The trial judge had concluded that the CERB payments should be deducted from her damages award for wrongful dismissal. And the employee subsequently appealed this decision to the Court of Appeal. And the Court of Appeal for British Columbia disagreed with the trial judge decision and held that this amount actually should not be deducted from post-termination income. And in weighing the broader policy considerations, the court concluded that any windfall that comes from a government income support program that is designed to benefit workers should go to the worker themselves rather than the employer. Now, in terms of takeaways, the decision in Yates was the first appellate level decision to consider this issue and has since been followed by the Alberta Court of Appeal. And it is reasonable to expect that this decision effectively settles the issue and basically confirms that CERB amounts will not be deducted from any wrongful dismissal damages going forward. So that brings us to the end of our formal presentation, and we will now move over to the Q&A portion.
Thank you, Connie. Thank you, everyone, and very helpful. Thank you for that. So we do have a lot of questions, not surprisingly. I'm happy to jump in and lead off with some of the questions related to the topics I covered. We got many questions in variations regarding the issue of changing your employment contracts. Let's say you have an old contract, could be, we've seen decades old, or just a contract that didn't anticipate Waxdale. What can you do? Can you change it? Can you give an employee new paper? And some of you also tipped off the issue of consideration. So I'll explain what that is to you in a moment when I answer that question, the consideration issue, and should you do it? Okay. So the answer is yes. So when an employee starts working, they have a contract. They either have a written contract, or if they don't have a written contract, they have a common law contract that's kind of in the air and around them, and a judge will fill in the details. But if you have paper and you have a contract and you want it changed because you're concerned about the termination provision, you can give a new contract to that employee, and it will be enforceable so long as there's an exchange of what the lawyers call consideration, which means an exchange of value. So the follow-up question is, well, how much, or what is the appropriate value? What's the right number for consideration? That's not, I guess, a particularly easy question to answer, but here's some thoughts. I'm old enough to remember back when I was a younger man, that you had to sell someone a car for at least $1, right? Like, even if it was a parent giving a car to their kid, they sold it to their kid for $1 to transfer the title. That's this same concept. Now, that was a bit of a farce. So stay away from that. Okay, we're not going to try to put an employee on new paper and give them some amount that is small. So it's got to be a bigger amount, you know, $500, $1,000. It's going to depend on how much the employee makes. And it's going to depend, I think, on the nature of the changes in the contract. I think you can buttress the enforceability of that new contract if you suggest independent legal counsel, if you draw attention to the changes. So the employee at least knows what the new contract means, right? Because I think if that part isn't taken care of, you're going to run a real risk that the court's going to think that this, you know, something was rotten in Denmark and it wasn't particularly fair. So should you bother then? Well, it's a difficult question to answer, right? If you have a whole bunch of employees on old paper what are you going to do if you try to get all 30 of them to sign the new agreement, and some do and some don't, and you have a bit of an issue? So there are still employers who decide, yes, we want to go ahead, and typically they'll decide to give a meaningful bonus, signing bonus, that is not a bonus they would have otherwise received. The employer will use that new template contract going forward, so it will certainly help with any new hires, right? Another opportunity that I like is if an employee, no, admittedly though, it doesn't come up as often, but if you have a circumstance where an employee is getting a promotion, particularly if there's an increase in remuneration, that's a good time to put them on new paper. Okay, so yes, you should, and you're gonna, it's not going to be an easy decision in terms of a big pool of employees who are already existing, but you should do it at least for your new hires, and you should look for opportunities like employees who are being promoted as a way to put new paper in place. I don't know if well, I'll do a couple more questions, then Connie, you can jump in, but if I'm going too long, which I tend to do, feel free to just pipe in and interrupt me. So there was also a question coming out of the Waxdale thing concept that I've explained, the problems with the Employment Standards Act causing without cause provisions to go by the wayside because of the impact on with cause, and the fact the Employment Standards Act doesn't use that term and it uses willful misconduct. So the question was essentially, well, what about, for example, federally regulated employers with the Canada Labor Code? And the answer is that the Canada Labor Code, even employment standards legislation in other provinces can use the word cause or just cause. It uses language that matches up more with the common law. So we haven't seen, so the Waxdale thing is less of a concern. I've called it twice the Waxdale thing, like it's a small deal. It's a big deal. And we haven't seen it spread. It hasn't taken root in other provinces, that sort of Waxdale type attack. So with these issues on termination provisions, question was also raised, do we have language that would help with the Waxdale issue? Yes, we have had, and we continue to have language that addresses that. So reach out to any of our shared accused lawyers for help with that. I'll take one more question, then I'll turn it to Connie, and then I'll probably pop back on to answer some more. There's a question about, so I had mentioned this, like how big that common law pool is, the month per year of service concept, and I'd actually shown you a few cases where employees are getting more than a month per year of service. Several of the cases that I put up there today, that's the case. But the question is, like, is there a ceiling? And the answer to that is, again, so the answer is yes. A soft yes. We've always, we being the legal bench and bar, the lawyers and the judges, sort of considered 24 months to be the cap or the roof. You don't find many decisions, if any, talking about it as a hard cap. It's the judges are allowed to do what they want to do and what they feel is fair. So you will see, and we have seen some cases that have quote unquote exceeded that 24 month ceiling. And it's now seems to be contained around exceptional circumstances. And what are truly exceptional circumstances, and if the employee can establish exceptional circumstances, we're still talking about, maybe going from 24 to 26 is the way the cases have sort of come through. So an example, the case that Connie was referring to, Russell and the Brick, of an employee who had only ever worked for the Brick for 36 years or over 30 years, his common law notice period was still capped at 24 months. He tried to argue exceptional circumstances, but he wasn't successful. So 24 months was still the maximum for that. That's an example of a case that went to 24 months, even though he'd been with the company for over 30 years. Connie, why don't you jump in and answer a couple of your questions?
Sure. Yeah. So we have a question that asked, can a terminated employee who signed a full and final release still file a claim for wrongful dismissal and or bad faith conduct? So an employee can always file a claim, but if they have an enforceable release on termination that releases the employer from any and all claims related to their employment, the release will likely bar the claim from proceeding. And that's why it's really important and valuable to employers to get the release, in that it can provide certainty that at the end of the employment relationship, the employer won't be facing a claim related to the termination. But what we see from these cases is that we want to make sure that any termination letter that has a gratuitous offer in exchange for a release makes it clear what will happen if the employee does not accept the offer and does not sign the release, meaning that they will still get their ESA entitlements, which includes the notice of termination and severance payments minimums under the Employment Standards Act, as well as benefit continuation. So while a release is helpful, oftentimes employees may decide not to sign the release, and you may still get a claim for wrongful dismissal and bad faith conduct. In terms of termination meeting timing recommendations, I think for best practices, it would be best to have the termination meeting either at the beginning or end of the day, either before the rest of the employees have come into the office or after everyone has left, where there's fewer people around and the employee can, exit without having been seen by too many people. It's also more of a discussion with the employee in terms of whether or not they'd like to get their belongings at the time of the termination following the termination meeting, or if they want to come back at a later point to pack up their belongings. But generally, I think the main idea is to be respectful of the employee and understanding that it is an uncomfortable and sometimes embarrassing situation to be in. So to the extent that we can try to minimize those feelings instead of making them worse, that would be best practices. There's another question about offering outplacement services and whether or not that impacts the potential of a bad faith claim. Likely not. I think the concept of outplacement services really goes to assisting the employee with mitigation, which Brian talked about, which is, stopping the bleeding and helping them find a new job. The sooner the better. But it doesn't necessarily impact a bad faith claim if ultimately the employee felt that the way that the termination was conducted was dishonest or was a breach of the employer's bad faith duties. But I think outplacement services is never a bad idea. It just may not significantly impact whether or not there was truly a bad faith in the way the employer behaved.
Yeah, and I have a few comments on this. So it's an interesting issue because for a very long time, I think, frankly, probably as long as I've been practicing, you'll see statements of claim in a wrongful dismissal claim for the value of outplacement services that the employer did not provide. And we always see it, and we see it over and over again. But the reality is there's nothing out there that obligates an employee to do that. Employer to provide outplacement services. We've talked about some of the reasons why you might want to, but haven't seen anything that said, well, you didn't, so you failed in some sort of obligation. Okay, whether it's bad faiths or even just a basic obligation, it's not part of a compensation package that you need to remedy for in a notice termination. That being said, again, we've pointed out some reasons why you might want to do that, and I would also perhaps add that particularly, some employers actually have an arrangement with an outplacement service provider where they have a good deal, and the cost of doing it is not terribly high. And frankly, there's other interesting issues. Never really gotten into a fight about it, but you'll probably have an idea of whether the person has used those services and whether or not they're actually trying to find work. So there's a few other things to think about as well tied to the outplacement services. If you don't mind, Connie, I'll jump in with a few more questions and then throw it back to you after. There were several questions about the issue of bonus, right? And so there was the case that I talked about where it used the word salary, but it didn't define what salary was, and the court decided that bonus was part of salary. There was language used in that case that talked about an integral component of the substantial and integral component of their remuneration. In that particular case, it was about 25%, up to 25%. So we've seen questions about, well, what if we have language that says you don't get your bonus? Yes, you can do that. Big surprise, I'm going to tell you that language has to be very good and precise. There's a line of cases. There's a particular case Dover is the name of the case, and we call it Doverizing language. We try to Doverize a contract and indicate that the employee is not entitled to bonuses during the notice period. The way that the cases have approached that issue is if they find that the bonus is a substantial and integral part of their compensation, you're going to need rock solid language drawn to the employee's attention that says that explains explicitly what happens with respect to bonus payments in relation to the notice period. And you're also going to have to be mindful of at least providing what the ESA would require, because this is, again, another area where the common law and the ESA can diverge, and the ESA uses the term wages. And in many cases, it can include a bonus, even if it's discretionary, labeled as discretionary. And so you want to, at the very least, protect for that ESA notice period, okay, in order for it to continue and sort of hold up. So what I'm telling you is you can do it. It needs specific, precise language in order to actually limit it. And the court will look, and so if we say, well, it's a discretionary bonus, well, they'll look, did the person traditionally get it? So in the case that I was referring to, Nader, the court did decide, if he had continued working, he would have received that bonus. He'd always gotten it. There's no evidence that there was a performance component ostensibly to the bonus, but he'd never not gotten it, and there were not performance issues that would have put it in jeopardy. So they decided he would have received it anyways. There was a question. So if you have a well-worded termination clause that provides only ESA minimums, but on termination, the company decides to provide an additional amount on a gratuitous basis, does that action jeopardize the whole term of the contract? And I would say no. I think you want to be clear in your termination letter, for example, here's what your contract entitles you to. We're giving that to you no matter what you decide, but we all so this actually could very well come up in a circumstance where you have a contract and you want to terminate in accordance with the contract, but you also want a release from the employee. You want to get a commitment from them that they're not going to come back and sue you for anything. So you can set up your letter. You can say, here's what your contract entitles that you to. We are giving you that, no questions, no obligations, but we want to treat you very well. Here's another thing we're going to give you, I don't know, outplacement service. It doesn't, I'm just picking on the earlier issue, but we'll give you this, and we'll juice up your notice by X amount, and all you have to do is sign this release and give it back to us. So that is not an admission that your language in your contract is not good. It's just open and direct communication to the employee that we're going to give you more, and here's what you have to do to get that more. But if you don't agree with that, if we don't sort of come to that new package and there's exchange of value, there's consideration there, then you're still going to get what you're entitled to under your contract. Your contract is still good. Okay, so short answer, no. Long answer, I won't repeat, but that's where that's how I see that. So Connie, I don't know if you want to grab one there.
Yeah, sure. So we had another question about proving mental distress caused by the loss of employment. And as you can tell from the case law, there isn't really a very strong evidentiary requirement to prove that the employer's conduct was the sole cause of mental distress. And as I mentioned earlier, there really is a recognition that the termination in and of itself is, without even any bad faith, can cause some certain level of stress. And so the courts are generally more focused at looking at behavior and looking at it from the perspective of whether or not it has caused some level of humiliation or mental distress that would go beyond what is expected in a normal termination situation. Another question is, would you advise against announcing the termination to the company the day after they happen? How would you approach letting the company know? So I think the cases do speak to, how we communicate the termination to other people, whether it's other individuals at the company or in a public setting. There's really nothing improper about advising others that this employee is no longer with the company. But I think we always want to stay cautious about talking about the reasons for the termination for the individual, especially to others who don't necessarily need to know the reason why someone is not with the company. And we may want to be discussing with, higher levels of management in terms of how we draft a notice of departure for an employee, and really preparing a uniform response should we get asked about the reason for their termination. And once again, going back to the theme of just being mindful of avoiding unnecessary embarrassment or humiliation to the employee.
I got some, so I've been through some more of the questions, some very good ones, frankly. So one question, what about termination provisions in an employment contract for a unionized employee? So unionized employees, the terms of their employment are governed by the collective agreement. You cannot bargain out of the Employment Standards Act. So the collective agreement has to comply with the Employment Standards Act as well. And it usually will. Unionized employees are not as easily terminated. Like you can't just decide to let them go from their employment. You have to look at your collective agreement, which will provide typically the circumstances under which they can be let go and lose their seniority. And typically the most frequent is a misconduct issue. Of course, if they're laid off, their employment's not ending. Their employment is just being it's just inactive while they're on a layoff. So numerous provisions in a collective agreement will touch those issues, but they also have to comply with the Employment Standards Act, and they almost invariably do, because unions and employers are careful when they negotiate those terms. So another question, if the employment contract includes language to protect the ESA minimums, does this help mitigate the risk of invalidation of a termination clause? Sadly, no. So what are we talking about here? You'll see, and I'm fairly sure in Waxdale, there was actually a provision that says, in no event will you receive less than the employment standards minimum requirements. I'm summarizing, but the point is a provision typically at the end of the contract that says, no matter what this contract says, you're never going to get less than your employment standards minimums. And much like the severability provision, where the contract invites the court to cut out rotten pieces and leave the rest, the court disregarded that catch-all protection provision. So again, just to be very clear, what I'm talking about in terms of a catch-all protection provision is something that says, no matter what all the rest says, no matter what we've said about entitlements on termination, we have no intention to give you less than your ESA. You will get your ESA. End of story. That does not save you. The court explains that by saying we can't invite employers to make mistakes or do improper things in the bodies of their contract and then just rely on a catch-all saving provision. I can't explain it any better than that. It's not what the court wants to encourage in terms of the responsibility on employers to draft clear and enforceable provisions that the employee can understand, instead of they might describe as nefarious sort of abstract concept of don't worry, you'll get whatever you're entitled to. Should we change the language to refer to willful disobedience, go away from just cause to speak to willful disobedience? Again, a matter I think I would invite you to speak to any of our lawyers, because we have language that we have had and continue to have, and tighten up the language regarding for cause and without cause, and really is there any use to have a distinction in your termination provision? Short answer, no. We're not taking that explicit reference as the way to solve the problem, but rather to just consolidate the provision and just talk again about the ESA minimums being protected in that termination provision. Another question related to the mitigation concept. How reasonable is it to expect someone to start looking for a job right away, especially a long-serving or older worker? What if they were dealing with emotional issues related to being terminated? So this is a good example where the lawyer answer of "it depends" is illustrated. So the question has provided the depending pieces, right? So we're talking about an employee who didn't see it coming. They've been with you for a very long time. It's extremely emotional for them. Might even be situation where they have a bout of depression, and they just can't get themselves going to find another job. The court would look at, so short answer, they're going to find some rope and play with the court, that I think the court would approach it and say they understood and understand that this person wasn't able to immediately jump out and go to job interviews. There aren't a lot of cases out there that talk about this, but I think the principles from the law are clear that when you're measuring an employee's efforts, they have to be reasonable. Okay. And what the court will do, so this is where I think everyone can sort of understand the concept of subjectively reasonable or objectively reasonable. Who gets to judge what's reasonable? The person who's doing it, or the average person on the street? And the courts approach it with sort of a blend. If you took the average person and you put them in the circumstances of this particular person, what would be reasonable? So the average person who's worked for a company for 30 years and is let go all of a sudden, didn't see it coming, needed a few weeks to get gathered. I think the court's going to give that person grace in terms of mitigation efforts. If it goes a little bit longer, then you're sort of morphing the case into circumstances that do arise, where you have a plaintiff claiming mental distress. And we do see those claims, and that can't come from the fact of the termination itself. So the courts have approached that by indicating that the employer is not responsible to compensate if the person is incapacitated or has an extremely difficult time by the fact of being let go, separate and distinct from the things that Connie talked about, right? Whereas if you're in the meeting and you're treating the person out obviously poorly, could be any number of things, comments about their work or their person or their family or anything like that. I mean, I don't know why anyone would do that, but sometimes unexpected things do happen. Then you do have like a direct trigger. We've treated you badly, you're suffering mental distress, that would be compensable. Okay, so I think that that covers the question. Connie?
Yeah, I think that brings us to the end of today's program, subject to any comments you have, Brian. We hope you found it informative. The video and slide deck will be available on our website in a day or so. And if we did not get a chance to answer your question, feel free to drop us a line. Our next HR review webinar will take place on Wednesday, June 7th, 2023. Mark it in your calendars. The topic is in the design phase, and we will send out an invitation in due course. And if you're on our mailing list, you will receive an invitation. If you were not yet on our mailing list and wish to receive our briefing notes, newsletters, and invitations to seminars and workshops, please subscribe through our website. It is the big red bar at the bottom of every page. And finally, we would be grateful if you would fill in the feedback form that will pop up on your screen once you close this Zoom webinar. Thanks again for joining us. Have a great day and happy International Women's Day.